Next is something that anybody who's studied securities law or securities litigation will be familiar with. That is a misrepresentation or omission. That is the fraudulent misrepresentation or omission of material facts related to an investment recommendation made by a broker. That is essentially a securities fraud claim, and it can be filed pursuant to Section 10b-5 of the Securities Exchange Act of 1934, and it's got to involve some aspect of fraud, deception, misrepresentation, non-disclosure or omission of material facts related to the purchase and sale of the security. So as I was talking earlier about timeliness of claim, this would be the type of claim, a fraud claim, that can have a later trigger date, and that can be the time when the fraud was discovered. So in order to support a misrepresentation or omission claim, you're going to have to be able to demonstrate that the investment recommendation made was a misrepresentation of a material fact. It could also be an omission if you fail to disclose a material risk. It must have been intentional or at least reckless. It's got to have taken place in connection with the purchase or sale. Importantly, it must have been relied upon by the investor. It can't simply be an assurance that was put out there into the ether and the investor didn't give it a second thought or rely on it in their investment decision. It's got to have been relied upon. And it must have resulted in an investment loss.